That's the end of our opening statement, so we're now going to turn to our witnesses. We have just one panel, and I want to welcome you all for being here today. Let me introduce each of you from my left to right. First is Professor David Vladeck, who's a professor of law at Georgetown University Law Center here in D.C. Next is Dr. William Maisel, who is director of the Medical Device Safety Institute for the Department of Medicine at Beth Israel Deaconess Medical Center in Boston. And then we have Dr. Gregory Kerfman, who is editor of the New England Journal of Medicine, and Bridget Robb, who is, I know that's that Welsh name, I always get it wrong, Gwynedd, Pennsylvania. And then is Mr. Richard Cooper, who is a partner in Williams & Connolly. And finally is Michael Kinsley from Seattle, Washington. Thank you all for being here today. Now, the way we work it, we have 5-minute opening statements. They become part of the hearing record. You may, in the discretion of the committee, submit additional statements in writing for inclusion in the record, after your testimony. And I'm going to start on my left again with Professor Vladeck.
Mr. Chairman, is this on? Mr. Chairman and members of the committee, thank you very much for inviting me to be here today. The bill, H.R. 1346, proposes to restore to consumers injured as a result of defects in life-supporting and life-sustaining medical devices the right to sue medical device manufacturers. My views are these. The Supreme Court ruled—
Professor, just move the mic a little closer, and I'm going to ask everybody to do the same. It'll be easier to hear you.
I think it's on.
It's on, but it's better to speak a little closer to it.
All right. My views are these. Regal versus Medtronic provides very broad immunity from tort liability to manufacturers of medical devices, and the ruling gives consumers the worst of both worlds. On one hand, the FDA cannot single-handedly assure the safety of the thousands of medical devices on the market today. Too many serious defects have emerged with FDA-approved devices, and too many patients have been killed or injured by defective devices to contend otherwise. On the other hand, in the aftermath of Regal, patients injured by devices are left with no remedy at all. No compensation for the pain and suffering they endure, no reimbursements for the costs of surgery and medical care, and no recompense to their loved ones should they die. Making matters worse, manufacturers have little economic incentive to swiftly recall devices or to repair defective devices on their market, since they are immunized from liability and tort. I recognize that Regal ruled that Congress, in passing the medical device amendments, conferred immunity from tort liability to device manufacturers. In my view, Regal is wrong as a matter of history, as a matter of law, and a matter of policy, and Congress ought to swiftly overrule it. First, Regal's wrong as a matter of history. As Chairman Waxman, Mr. Dingell confirmed, the members of Congress who enacted the medical device amendments know that Congress never intended the medical device amendments' very narrow preemption provision to restrict the rights of injured parties to sue for compensation. Cutting off tort liability was not Congress's goal in that statute. Second, it's wrong as a matter of law. The medical device amendments were passed to strengthen consumer protection. The statute was passed in the wake of the notorious failure of the Dalkin Shield, an intrauterine device that harmed and killed many women. The legislation was intended to strengthen consumer remedies, and it is odd in the extreme to say that Congress intended to insulate manufacturers from the tort liability that was instrumental in bringing justice to people injured by defective medical devices. The last point, and the most important point, is that Regal is wrong as a matter of policy. Immunizing device manufacturers, and device manufacturers alone in terms of manufacture of medical products, harms the public in several ways. First, immunity removes incentive to manufacturers to fix devices quickly and get defective devices off the market. Time and again, we've seen device manufacturers find defects in their devices, make important safety improvements, yet continue to sell their older, riskier devices until they sell out their inventory. Tort law would constrain that practice. Second, immunity weakens the incentives to disclose defects to physicians and patients without delay. Again, time and again, we've seen device manufacturers fail to do that. Again, tort liability would constrain that practice. Third, immunity eliminates the compensatory justice role served by the civil liability system. It shifts all of the costs of injuries and deaths from the manufacturers onto consumers who can ill afford it, to insurance companies, and ultimately to taxpayers. What we've done is simply shift the burden of risk off the manufacturer onto the shoulders of the taxpayers. The arguments that defend Regal are off target, and history proves this point. Life-saving and life-sustaining medical devices have been marketed for decades. For all but a very brief period, there's been no preemption. Preemption is a fleeting phenomenon. It has not been the norm with respect to medical devices. Yet, for virtually all of the time, FDA regulation and state tort litigation have coexisted, each placing an important but complementary discipline on the marketplace, without impairing the FDA's function and without any of the harms the defenders of Regal fear. For instance, the United States industry for medical devices remains and has always been the most innovative in the world. The American manufacturers of medical devices dominate the international market, even though there's long been a backstop of tort liability. I see my time is up. Let me just make one last point. The Supreme Court in Regal said that preemption was decreed by Congress. Congress has the power to fix it. I urge that Congress restore consumers to the place they were prior to Regal without delay. Thank you very much.
Thank you, Professor. Dr. Maisel.
Thank you, Chairman Pallone, distinguished members of the committee. Thank you for the opportunity today to speak about the importance of the Medical Device Safety Act of 2009. My name is Dr. William Maisel. I am a practicing cardiologist at Beth Israel Deaconess Medical Center and assistant professor of medicine at Harvard Medical School in Boston. And I'm also director of the Medical Device Safety Institute, an industry-independent nonprofit organization dedicated to improving the safety of medical devices. I have served as a consultant to the FDA's Center for Devices and Radiological Health since 2003, and I have previously chaired the FDA's post-market and heart device advisory panels. I hope that by the conclusion of my brief remarks today, you will appreciate that FDA marketing approval of a medical device does not guarantee its safety. In particular, manufacturers' responsibilities for product safety extend well beyond initial FDA approval, and it is apparent that additional consumer safeguards are needed if we are to improve the safety of medical devices for the millions of patients who enjoy their benefits. We are fortunate to have the preeminent medical regulatory system in the world. The U.S. Food and Drug Administration regulates more than 100,000 different medical devices manufactured by more than 15,000 companies. They receive several thousand new and supplemental device applications annually, and they are mandated by Congress to complete their pre-market evaluations in a timely fashion. Mark Gleason is a man whose very life depends on one of these implantable medical devices, in his case a pacemaker. Pacemakers are implanted to treat dangerous slow heart rhythms, and in Mr. Gleason's case, every single beat of his heart comes from his device. The pacemaker itself consists of a battery and computer circuitry sealed together in a metal housing. Although pacemaker batteries typically last 5 to 10 years, Mr. Gleason required surgical replacement of his pacemaker after just 12 months due to a short circuit that caused the battery to wear out prematurely. St. Jude Medical, the manufacturer of Mr. Gleason's pacemaker, had become aware of the short circuit problem 2 years earlier because other faulty devices had been returned to the manufacturer. St. Jude asked for and received FDA approval for a modified version of the device that corrected the problem, although they continued to distribute already manufactured, potentially faulty pacemakers with the FDA's knowledge, but without public disclosure. When Mr. Gleason needed his faulty pacemaker replaced, he received another potentially faulty device, even though corrected pacemakers had been built and were available. Ultimately, St. Jude Medical issued a recall of 163,000 pacemakers, including Mark Gleason's new unit, but not until nearly 2.5 years after initially learning of the problem. As Mr. Gleason wrote to me, It is unacceptable that St. Jude Medical was permitted to continue to sell known defective inventory of a device with impunity. One possible conclusion is that St. Jude Medical weighed the likelihood of death or serious injury against the cost of pulling defective inventory off the market. While Mr. Gleason's case occurred several years ago, it is not an isolated event. Other manufacturers have also knowingly sold potentially defective devices without public disclosure. The FDA annually receives reports of more than 200,000 device-related injuries and malfunctions and more than 2,000 device-related deaths, and it is challenging for them to identify patterns of malfunction among the deluge of adverse event reports. In the majority of cases, FDA relies on industry to identify, correct, and report the problems, but there is obviously an inherent financial conflict of interest for the manufacturer that's sometimes measured in billions of dollars. The U.S. Supreme Court, with their February 2008 decision, Regal v. Medtronic, removed an essential consumer safeguard, the threat of manufacturer liability. Implanted medical devices have enriched and extended the lives of countless people, but device malfunctions and software glitches have become modern diseases that will continue to occur. The failure of manufacturers to provide the public with timely, critical information about device performance and malfunctions enables potentially defective devices to reach unwary consumers. Patients like Mark Gleason are sometimes forced to make life-changing decisions with insufficient and sometimes inaccurate information. We have consumer protections for airline passengers, for cable television customers, and for cellular telephone users, but surprisingly few for patients who receive life-sustaining medical devices. The Medical Device Safety Act of 2009 provides important and necessary consumer safeguards that will minimize adverse health consequences and improve the safety of medical devices for the millions of patients who enjoy their benefits. Thank you.
Thank you. Dr. Kerfman.
Thank you, Chairman Pallone and other distinguished members of the subcommittee. I want to thank you for inviting me to participate in this important hearing. My name is Gregory Kerfman. I'm the executive editor of the New England Journal of Medicine. I will argue that preemption of common law tort actions against medical device companies is ill-advised. Preemption puts the interest of corporations before the interest of patients. It denies patients their rights and will result in less safe medical devices for the American people. For nearly 200 years, the New England Journal of Medicine has been publishing articles on innovative drugs and medical devices. We strongly support medical innovation. We are a medical journal. But we are a patient-focused medical journal, and we are committed to patient safety. Now, Mr. Chairman, innovation and safety are not mutually exclusive. We can and we must have both. Patient safety is a national concern. Major stakeholders throughout our healthcare system agree that every step must be taken to ensure that medical interventions are as safe as possible. Unfortunately, one major stakeholder, the medical device industry, has been shielded from the potential consequences of failing to adequately disclose risks. This was the result of the U.S. Supreme Court decision in Regal v. Medtronic. Until that ruling, the possibility of litigation for failure to warn or design defect served as a strong incentive for device companies to be vigilant about the safety of their products. Medical devices are often approved on the basis of only small, short-term clinical trials, and a number of devices have been approved through a fast-track process that does not require any clinical testing at all. The approval process leaves patients vulnerable to safety problems that have gone unrecognized during the pre-marketing period, only to emerge during the post-marketing period. Since the Regal ruling, as Chairman Waxman mentioned, thousands of lawsuits against medical device manufacturers have been tossed out of court by judges following the Supreme Court's lead. Now, litigation, or the threat of litigation, has been effective in removing potentially harmful medical products from the market. And there are a number of examples. They include the diet pill dexphenfluramine, or Redux, the COX-2 inhibitor rofecoxib, or Vioxx, and the cholesterol-lowering drug cerevastatin, or Baycol. But the examples are not limited to drugs. A number of medical devices have been removed from the market after injuries and litigation. Among them, the Dalcon Shield that Professor Vladeck mentioned, the Bjork-Shiley heart valve, and recently the Sprint Fidelis cardioverter defibrillator lead that we will hear more about. Mr. Chairman, let me be clear. I am not here to promote lawsuits. I am here to promote the interest of patients. I oppose preemption because it removes a legal mechanism by which patients who have been harmed can be compensated, and because it will inevitably result in less safe medical devices for the American people. The way to prevent lawsuits is to put safe medical products on the market. The Supreme Court's ruling in Regal was based not on considerations of what is best for the health of the public, but rather on a point of statutory law. In marked contrast to Regal, the Supreme Court ruling last March in the drug preemption case, Wyeth v. Levine, dismissed Wyeth's argument that failure to warn suits against drug companies are preempted by FDA approval of the drug's label. Now, as the law stands, failure to warn and design defect lawsuits are preempted for medical devices, but not for drugs. This perplexing state of affairs defies all logic. The Medical Device Safety Act of 2009 addresses this legal inconsistency. The bill would nullify the court's ruling in Regal and would thereby place medical devices and drugs on a level playing field with respect to patients' rights. I urge you and your colleagues in Congress to swiftly pass this legislation. The critical issue of preemption should be decided by officials elected by the people. Mr. Chairman, I hope that this testimony is informative, and I look forward to answering any questions that you may have.
Thank you, Doctor. Ms. Robb?
Chairman Pallone and members of the Health Subcommittee, thank you for inviting me to speak to you about my personal experiences with a faulty medical device and my reasons for supporting the Medical Device Safety Act, H.R. 1346. My name is Bridget Robb, and I'm a 35-year-old mother and resident of Gwynedd, Pennsylvania. On December 31st, 2007, I suffered greatly and thought I was going to die because of a defective heart device implanted in my body. I'm thankful to be here today, and I am pleased that Chairman Pallone has reintroduced the Medical Device Safety Act, which would restore the right of patients like me to hold manufacturers accountable when their products cause injury and sometimes even death. Approximately 5 years ago, I was diagnosed with non-ischemic viral cardiomyopathy and congestive heart failure. In May of 2005, to prevent me from dying from a fatal arrhythmia, I had a Medtronic cardiac defibrillator implanted in my chest. This heart device is a small metal case that contains electronics and a battery. Its components work much like a pacemaker, but unlike a pacemaker, an ICD delivers an electrical shock to the heart when the heart rate becomes dangerously fast. On December 31st, 2007, I was awoken from my sleep by a series of shocks to my heart, which felt as if a cannon was being repeatedly shot at my chest at close range. Along with these recurrent shocks was a strong electrical current racing through my body. After feeling the first shock, I immediately phoned 911 for help. My then 6-year-old daughter, Emma, had snuck into bed with me that night and was present during this horrific experience. I remember Emma being scared and confused. She crouched down in front of me, hugging our cat, saying, "Mommy's dying." She was present during the entire 7 minutes that I was on the telephone with the 911 operator until the EMS arrived. I cannot imagine how terrified she must have been to see her mother in such pain. My doctors have told me that I received a total of 31 dangerous shocks to my heart in a matter of minutes that morning. Each time I was shocked, I saw my life flash before my eyes. It was excruciating pain. At one point, I began to pass out and thought that I would never see Emma again. Every day since then, I've been unable to sleep. Ever since that day, I've been unable to sleep in my own bed due to the trauma that I have experienced. I later learned that the agonizing shocks and electricity coursing through my body was caused by a defective cardiac lead implanted in my heart, the Sprint Fidelis lead, manufactured by Medtronic. A lead is a thin wire that connects the ICD to the heart and delivers the actual shock to the heart when it is beating too fast. Medtronic's Sprint Fidelis lead was recalled on October 15, 2007, because of its potential to fracture. Despite receiving over 1,000 complaints about the defective lead, it took Medtronic 3 years to issue this recall. Since this terrifying experience, my health has declined significantly. I visit doctors weekly because of my ongoing health issues due to this event. After the inappropriate shocking from my lead, I underwent surgical replacement of my defibrillator and defective lead, and a second surgery to adjust the new lead. My second surgery resulted in an extended hospital stay where I had to undergo a blood transfusion. Most recently, in September 2008, my incision ulcerated and became extremely painful. I was hospitalized a series of times, once for 2 weeks straight, in an effort to cure this problem. To prevent an infection to the hardware in my chest, my doctors ultimately decided to remove my defibrillator altogether. Right now, my doctors continue to try and stabilize my decreased heart function, and I take various medications that carry serious health risks, which I never took before. As you would expect, I risk serious harm each time another procedure is performed. From the time between my diagnosis in 2004 and the horrifying shocking in December of 2007, I was never hospitalized for my heart failure except to have my defibrillator implanted. My heart function had significantly increased due to my medications, and I had a good outlook from my doctors. However, since my defective lead misfired, I've been hospitalized at least 8 times, mostly for 1 to 2 weeks at a time, and my heart function is much lower than it used to be. I'm a single mother, so as you can imagine, this has been trying for both my daughter Emma and myself. Each time I'm hospitalized, it becomes more difficult on my daughter, since she is afraid that one of these times I won't come home. Even though Medtronic's defective device caused my injuries, my health insurance plan has been paying for the cost of my medical care. It is wrong to shift the cost of medical care from the responsible party to private insurers, patients, and in some cases to taxpayer-sponsored programs like Medicare and Medicaid. I would like to have the opportunity to hold Medtronic accountable for the injuries that I suffered that day and the physical and emotional after effects that I continue to experience on a daily basis. I find it discouraging and demoralizing that I have no recourse for my injuries, and that a company that manufactured a defective product that has harmed me and thousands of other individuals has no accountability. I encourage Congress to act quickly and pass the Medical Device Safety Act. It is extremely important that injured patients have a remedy for their injuries and that the cost of their medical expenses and other needs are not borne by Medicare, private insurance, employees, and patients themselves. The medical device industry should be accountable for their products, just like the drug companies or any other industry. Thank you for your commitment to this critical issue. I am happy to answer any questions that you may have.
Thank you, Ms. Robb. Thanks so much for being here.
Thank you.
Mr. Cooper,
Thank you, Mr. Chairman, members of the subcommittee.
you have to get that mic closer to you. And
Thank you, Mr. Chairman, members of the subcommittee for inviting.
is it on?
Yes, green light.
All right, maybe just a little
Out.
closer. It'll be.
For inviting me to testify here today. I am here on my own, not representing any organization.
I don't know if it's working, Mr. Cooper. I'll try that.
I'll try this one.
That's
Yeah.
much better.
I'd like to make 3 points. The first is a number of the opening statements referred to what the members called defective devices. The fundamental issue here is who ultimately decides whether a device is defective. Is it the physicians, the engineers, the materials scientists, the chemists, the statisticians, and other experts at FDA? Or is it juries and judges in the 50 states and other jurisdictions that will hear products liability cases? By what process should that decision be made? By people who review enormous volumes of data, who over time, even after approval, receive reports from manufacturers of malfunctions or injuries, who can commission special studies, who can send inspectors into manufacturing plants to review all of the manufacturing records and interview the employees who design and manufacture the products? Or should it be people who listen to a couple of lawyers rant at them and observe witnesses being examined and cross-examined? And what perspective should guide that decision-making? The perspective of people who look at all those who will use a device, those who will benefit from it, as well as those who will suffer from malfunctions, or a group that spends day after day in court observing an injured plaintiff. I submit to you that the ultimate decision should be made by the Food and Drug Administration, which, if properly funded and subject to proper oversight, is a national treasure. Second, products liability law is not insurance. It's about fault. And a manufacturer that puts on the market a product with a design approved by the Food and Drug Administration, with the perspective I've described, by the experts I've described, and with the procedure I've described, is not at fault for marketing a device with that design, and similarly for other aspects of a device that FDA approves. Third, the concern about the effect of products liability litigation on incentives for innovation is not mere theory. It's real. A number of years ago, I served on a committee of the Institute of Medicine that issued a report. The report came out in 1990, called Developing New Contraceptives, Obstacles and Opportunities. And one of the principal obstacles to innovation in that medical field that the committee, which included primarily physicians, that the committee identified was products liability. It summarized its conclusion from its analysis as follows. I quote from its report: "Without changes in the products liability rules and procedures, it appears likely that even fewer firms will allocate even fewer resources to contraceptive research and development." Close quote. That's just one small medical field, and indeed a field that probably doesn't involve devices to which preemption under Regal would apply. But the effects of products liability risks are great. Most medical device companies are small. To develop a product in a field that has great risks of litigation is to bet the company on every product. And that isn't prudent when there are other things that can be done. And since 1990, and this report was issued, there hasn't been a lot of innovation in contraception. And there are other medical fields which are underserved due to liability risks. So that is something I would suggest you consider. This isn't corporations versus people. This is how best to serve people, how best to serve patients who need medical devices, whose lives are supported or sustained by medical devices, and whose adverse health conditions can be greatly alleviated by them if companies have the incentive to develop them and they're presented to FDA for its review. Thank you.
Thank you, Mr. Cooper. Mr. Kinsley?
Does this work? No. All right.
Here, why don't I switch seats with you for the moment?
Okay.
Good idea to switch seats.
Thanks for this opportunity to testify, Mr. Chairman. I'm here because I was approached last week by Medtronic, but I'm here representing myself. I'm not accepting anything from them except for Xeroxing of copies of my testimony. I also have I'm not an expert on federal preemption issues, and I don't even have a view about the question of whether standards should be similar between drugs and devices. I also have no view about the goings-on in the 11th Circuit, although it sounds pretty exciting. I'm here for two reasons. First, as a grateful customer of the pharmaceutical and medical device industries. I have Parkinson's, and I've had it for over 15 years. As I hope you can see for yourselves, my symptoms are pretty mild after all that time. They have not affected my ability to work, to travel, or to enjoy life. This is true thanks in part to drugs, including many that have just come on the market in the years since I was diagnosed. And it is true especially because of surgery I had 3 years ago called deep brain stimulation. Now I walk around with wires in my head and 2 pacemaker-type batteries in my chest. But thanks to these devices and these pills, I am walking around, which is encouraging to me. I'm also here as a journalist who's written quite a bit about the damage done to our economy and to our country by excessive litigation in general and product and medical liability lawsuits in particular. And with all due respect to Dr. Kerfman, if he thinks that companies can avoid litigation simply by producing safe products, I think he's naive. We all want the government to protect us from dangerous drugs and devices, but we don't want the government to prevent us from getting helpful or life-saving drugs and devices. And the central problem is that those are the same devices, the ones that threaten us with harm sometimes and the ones that help us most of the time. And you do not want a system, even if you could have it, that only allowed safe devices to be produced, because that would be too far over on the scale. You need to have, in order to maximize the benefit, you have to tolerate some risk. And the danger of using litigation to solve these problems is that it forces us as a society to be overcautious. I think I'll even stop there.
Thank you, Mr. Kinsley. Thank you all.